Hello everyone, today we will talk about Mareva injunction. What is Mareva injunction? In a simple meaning, Mareva injunction is a freezing order or asset preservation order. This injunction prohibits a defendant from transferring property beyond a court's jurisdiction to oppose a ruling. Where does Mareva injunction originate from? In the case of Mareva Compania Vera is where this particular type of injunction gets its name from. What happened in this case? This case is about a dispute over shipping, and the defendant was an international organization with funds in an English bank. Because the defendant lived in a different country and the money could be moved to a different place, there was a big chance that the defendant would take the funds and leave the plaintiff with no option, even if the plaintiff won the legal dispute. Therefore, the injunction was given the name Mareva injunction because it was obtained by the English Court of Appeal to safeguard the funds from being squandered.
Good morning, madam everyone. My name is Lizika, marriage number 281751, and today I represent on the historical backgrounds and development of Mareva injunction in both England and Malaysia. The historical background of Mareva injunction in Malaysia can be traced back to its origins of development in England before 1975. During that period, it is not the norm and practice of the English court to grant injunctions orders to restrain a person from dealing, disposing, or seizing a person's assets before trial or judgment is delivered, except in the cases of fraud. It was all until in one landmark case decided by Lord Denning, which led to Mareva injunctions being introduced in 1975 in England, which is known as the case of Mareva Compania Vera SA versus International Box Carrier SA. In this case, Mareva injunctions was granted by the court in favor of the ship owners to claim unpaid hires from the charterers, to restrain the charterers situated in foreign country from disposing of their assets out of their jurisdictions before the judgment was satisfied. The scope of Mareva injunction was later expanded to also include the local defendant in a situation in which the defendant and his or her assets are within the jurisdiction of the court. Another major development in the Mareva injunction was its availability to use to freeze the disposal of the assets located outside the jurisdictions by virtue of Section 25 of the Civil Jurisdictions and Judgment Act 1982. It gives the English court power to grant freestanding interim relief in aid of the foreign proceedings anywhere in the world and also to freeze the future assets. Within this context, the judgment adjudicated needs to be registered in the foreign countries where the assets are located for the enforcement of the orders. However, the execution of Mareva injunction in Malaysia before 1984 did not get a good start because the Malaysian court at that period of the time had no jurisdictions to grant such a relief, and there were already legal remedies provided under the Debtors Act 1957 by way of attachment of properties before judgment, which rendered the equitable remedies of Mareva injunctions seeming redundant, as there were already securities to be lodged at the stage of initiation of the suit provided under the Act. It was until in 1984 that the issues on the existence of attachment before judgment has been resolved in the case of Pacific Center Sendirian Berhad versus United Engineers Berhad, and the court held that the Mareva injunction is a type of preventive relief that can be applied before or during trial, and it can be ex parte or inter partes in nature to prevent any defendants from disposing their assets as to leave the plaintiff with nothing remaining to satisfy the judgment. It was only in 1984, in the case of Zainal Abidin versus Century Hotel Sendirian Berhad, the Mareva injunction was introduced in Malaysia to fulfill commercial needs, to restrain the foreign defaulters from dissipating their funds or assets in this country. Later, Malaysia adopted three guidelines introduced by Lord Denning in the case of Third Chandri Shipping Corporation and other versus Unimarine SA before granting any applications for Mareva injunction. First, the plaintiff must show that he or she has a good arguable case. Second, the plaintiff must produce evidence to show that the defendant has assets within the jurisdiction. Third, there's a risk of assets being removed before the judgment is satisfied. Following the case of Bank Bumiputra Malaysia Berhad and others versus Lorraine Osman and others, it shows that the courts also willing to extend the applications of Mareva injunction in Malaysia to assets located outside of jurisdiction. In this case, Mareva injunction was granted to freeze the assets of defendants not only located in Malaysia, but also in Hong Kong and England in relation to the secret profits made by them without the approval of the plaintiff. Furthermore, The application of Mareva injunction in Malaysia is not restricted to prevent the removal of assets from jurisdiction, but also extends to dissipations within the jurisdictions, as shown in the case of Quashhawk International Limited versus Jayawa Sendirian Berhad and others. The court in this case held that the sole purpose of Mareva injunction is to prevent a plaintiff from being cheated out of the proceeds of actions by a defendant transferring his asset abroad or dissipating his asset within the jurisdictions. In brief, Mareva injunction is a type of interlocutory injunction in which, when granted, the order will continue until a specific time or until the further order of the court. Particularly, it is very useful in the commercial law. To date, Malaysia has adopted most kinds of the injunction under the English law, with provisions provided under the Specific Relief Act 1950. That's all from me. Thank you.
Now, let's take a look to the current position of Mareva injunction in Malaysia. In Malaysia, we have few equitable remedies and most of them has been clearly stated in the Specific Relief Act 1950. However, when regards to Mareva injunction, there is no provision that stipulates this particular injunction directly for its administration and application. Hence, by virtue of Section 3 of Civil Law Act 1956, the law requires Malaysian courts to follow common law and previous verdicts to set a precedent for new cases in regards to Mareva injunction. Here are some principles of Mareva injunction that have been laid down in previous cases that may be used until this day. First of all, in the case of Wong Ho Enterprise Sdn Bhd, the High Court failed to consider that the Minister of Education who had not approved the payment certificate. The unresolved claim led to ambiguity about the cause of action and a weak case. As provided by my friend earlier about the 3 guidelines for granting Mareva injunction, this case stresses the need of a good arguing case where if this is missing, then the court shall not grant an Mareva injunction. Next, in the light of Polyelectronic and Electrical Sdn Bhd, where the court issued the Mareva injunction against a Korean corporation and its South Korean directors, the plaintiff obtained an Mareva injunction preventing the defendant from disposing or handling its asset until the court issued an order. This case laid down the principle of necessity to suppress misuse by non-citizen residents that could prompt the removal of assets from the jurisdiction to safeguard any pending decision in the nation. Last but not least, we can also see 2 more principles that have been laid down by 2 different cases. Mareva injunction may be also used in lifting the corporate rule as applied in the case of Aspotra Sdn Bhd against Bank Bumiputra Malaysia. Not just that, Mareva injunction can be used by the public, not just individuals. This has been laid down in an action to protect investors. The Securities Commission on 6 September have obtained a Mareva injunction to prevent the Air Molek Rubber Company Berhad and its solicitor from disposing of or dealing or dissipating any of its assets in or outside Malaysia before the dispute.
Good day, Doctor. I'm Mo Yin Yang, metric number 280263. Today, I'll be casting light on the relationship between the Mareva injunction and family disputes in Malaysia. Diving in depth into the case of Mangalam, as heard by the Kuala Lumpur High Court, it was an attempt to prevent a husband from dividing up the family's assets before the divorce hearing to maintain the status quo. The petitioner or the wife appeared before the court and lodged a petition for judicial separation. Meanwhile, the respondent or the husband filed for divorce after roughly 10 months. The court then ordered that the petition to be heard simultaneously. The wife then responded to the divorce petition in the interval, reserving her right to oppose and rest initial concerns. The wife asserted that the husband was surreptitiously spending money using cunning means. As a result, the court allowed an ex parte application for restraining orders by route of an interlocutory injunction. Later, an order setting a new hearing date prolonged the interim order. The husband's lawyer submitted an application to strike down the interim injunction before the hearing between the parties. The husband voiced concern to the court that the injunction had suffered him tremendous hardship because his assets and money were frozen and he was unable to access to them to settle for various outgoings. The wife then lodged a further application to the court, demanding that the interim injunction order to be extended until the day which both parties' petition are disposed. One of the cases that the husband relied on is the case of motorsports, where the court ruled that a plaintiff claims an exact sums for Mareva injunction. In this scenario, a Mareva injunction that restrains the defendant from dissipating his assets must specify an upper limit. If it doesn't, then the order is liable to be condemned as being too wide and oppressive. Nevertheless, Faisal Dambi, Chief Judge, delivered his judgment that in this case, the plaintiff claimed an exact amount but didn't specify an upper limit, which is an essential requirement to get Mareva injunction. Back to our case, the petitioner or the wife didn't plead for any exact sums. In fact, she couldn't do so because this is a matrimonial dispute and she doesn't know the limit of assets owned by the husband. Thus, the court then dismissed the application from the husband as he relied on the cases dealing with Mareva injunction. The cases cited are not germane and inapplicable to this case, which involves interlocutory injunction under Order 29 of the Rules of Court 2012. Thus, the distinction is paramount since the Mareva injunction has always been seen as a particular type of interlocutory injunction. In line with Section 11, Subsection 1, Paragraph A and Paragraph B of the Arbitration Act 2005, it says that before or during arbitral proceedings, a party may request any interim measures from a high court, which includes interim injunction. In this context, the High Court may issue any order for the party to retain or restore to the status quo while the dispute is still pending to be resolved, or take steps to stop or avoid from taking steps that could impair or prejudice to the arbitral proceedings currently or in the future. It is tailored to guarantee that any award obtained during the arbitration process is not rendered ineffective due to a party's asset dissipation. As all we know, the asset is the fundamental basis of the arising disputes between both parties. Thus, once the asset is vanished, then it will pave the way for unfavorable, partial, and nullified outcome. In a nutshell, from taking a glimpse at the precedented judgments that had been awarded by the courts in Malaysia and England, we can observe that Mareva injunction has gradually developed through decades. Undoubtedly, it is underscored as an equitable preventive relief by the courts in its very own distinctive requirements as a type of interlocutory injunction. Indeed, it is inevitable that the injunction, or in particular the Mareva injunction per se, has abundance of offers in terms of serving as an instrument of equity and justice. This is inextricably related to the notion that a Mareva injunction guarantees a judgment rendered in the plaintiff's favor won't be overturned merely by the defendant's action for the ultimate goal of justice.